Hello, everybody. First, I would like to thank a few people, the organizer of this conference. They have done a very important job. It's important to speak about Europe in these days. You know, the President said it before. The rules are not always respected in Europe. It's a very good thing to have organized this colloquium so we can speak about Europe and defend Europe. I have the honor to open that second roundtable with a subject which is the improvement of the protection of the rights of the migrants. Since 2015, the European Union has been facing major challenges in the field of migration. The events of the and the denial of solidarity between the member states have revealed the failure and unsustainability of the European asylum policy, which directly impacts on the fundamental rights of migrants. You remember on the November 24, the tragic shipwreck of Calais. You remember all that shipwreck of Calais, which resulted in 27 deaths, highlighted the poor condition under which asylum seekers are treated, reigniting diplomatic tensions between France and the United Kingdom. In 2021, more than 28,000 people made crossing, 3 times more in number as in the previous year. The recent humanitarian crisis at the Polish border has highlighted the possible instrumentalization of migrants by a third state for political purposes. Against, I said it before, against this worrying background, the European Commission presented a draft pact on migration and asylum. It was presented on the 23rd of September 2020 or 21. This draft brings together 5 legislative proposals and recommendations to member states. The aim is to address the shortcomings on some problems which are not going well, which is actually the current legal framework, in order to establish a more comprehensive approach to asylum and migration management. This pact is very much criticized nowadays because it favors a security approach to the detriment of the respect of procedural guarantees for asylum securities. So what does it consist, this pact drafted pact? First of all, the Commission's proposal focuses on preventing arrivals at Europe's borders. It proposes the development of a partnership, something new, to carry out returns more efficiently and to delegate asylum management and border controls to third countries. For some, they may think that to delegate this type of things, they could argue that this externalization of migration policy could lead to more illegal returns and arbitrary detentions. This would lead to a second regulation, a sort of screening of third country nationals at the external border. This procedure of screening would be carried out without the persons being considered as being on European soil, in application of a new principle of legal fiction of non-entry. So what could happen? The authorities will then be able to direct asylum seekers to an accelerated procedure, which would, it's important to know, which could be automatically applicable to migrants whose nationality has less than a 20% protection rate in the Union. So the legislation, the provisions, the current provisions make no provision for an independent monitoring mechanism, nor does it have does it see an access by lawyers to these areas? In this project, PAC draft, it takes up the philosophy of the Dublin III regulation, maintains the criterion of the member state of arrival to determine the state responsible for the asylum application. So the Commission also provides for another principle of compulsory relocation, but with certain adjustments. The member states will thus be able to favor alternative solutions, either by sponsoring returns or by providing operational support for the return of the migrants, which will, you understood, raise criticism of as far as the principle of solidarity between states is concerned. So, where do we stand today? The Pact on Migration and Asylum is currently under consideration by the European Parliament, and in the absence of progress in the negotiation between the member states, the French presidency will have a hard task, a difficult and hard task, of leading the future discussion in the Council of the European Union to reach agreements. What are the questions? They're numerous, but we have determined a few of them, 3 actually. The questions which has been asked today: how to improve the respect for the fundamental rights of migrants. How to improve, yeah. Second question, the proposals I've just spoken about for a new European asylum policy, do this proposal respond to current problems or not? And third question, what is the place, what is the role of the lawyers in this situation? To answer these questions, we're supposed to have 4 experts. We have 3 of them here on the table. Philip Worthington, 4th expert, couldn't come today because he has been caught by the COVID. He is a contact case. So his presence would have been essential because he could have, in a practical way, be able to talk about what is happening in Lesbos. That's where he is at the moment. We have 2 other experts in this field, which will answer the 3 questions that I have just put on the table. So these 4 experts are very important. You will see the analysis they make about the legal aid, about the control mechanism, to have a good notion of this control mechanism, as well, and some ideas for reflection and proposals for improvement. We have to, as long as France is holding the presidency of the Council of the European Union, we have to be able to make proposals for improvement. So we are pleased to welcome Maître Laurence ROQUES, who is member of the Conseil National Liberté, the famous Commission for Liberty, we call it, of the CNB. And she's a lawyer at the Val-de-Marne. We have Noemí as well, VELASCO, Noemí ALARCÓN VELASCO, President of the Migration Committee of the Council of Europe Bar, and she's lawyer at the Malaga Bar. And she will tell us about the latest activities and the positions of the Council of European Bars. We are going to hear with great attention Leyla KAYACIK, which it's the first time that she's taking the floor in the Assembly. She took up her new post as the new Special Representative on Migration and the Refugees on the 1st of January. And she will speak about the activities and the recommendations of the Council of Europe. So you have the different speakers. We'll have a different type of round table because we have 3 subjects: access to justice, monitoring, access to monitoring, and monitoring steps, And third, the different propositions we should be able to make. So the first subject, I turn to Laurence ROQUES, access to justice. Ask following question: what actions are put into place by the National Council to give judicial aid to asylum seekers? Time is limited. We only have 4 minutes each of you. So 4 minutes to give us your message. Actually, you have only 2 minutes each, because actually you answer the question that should be given by one person. You have to share the 4 minutes in 2 people, so 2. Hélène, thanks a lot. Miss Hélène Fontaine. The title could be turned in another way towards the authorities, local, how to improve the protection of the rights of asylum seekers, of migrants. As it has been said at the Court of Justice, the Human Rights Court, we know how to improve the rights of the migrants. We activate a certain number of propositions, but the state must agree. France, which is now holding the presidency of the Council of the European Union, Pact of Migration, doesn't change anything about this policy of closing the borders, which is in course now, and the externalization of the borders, which is not I would not call it a screening, you call it taking the good migrants and not taking the bad ones. This is judicial fiction, I would call it. We call it a waiting zone. France has been condemned by the Court of Human Rights in '92, it was. There was no possibility for the lawyers to go into this waiting zone, and there was no decision, the written decision, allowing detention. And today, it's the same. Detention is not object of a written decision with the possibility of recourse. So France would be proud to complete this pact with an effective right to have the possibility to oppose to that. And the contentions will not be about Article 8 of the Convention of Human Rights, but arbitrary detention. So as far as the law is concerned, we know what human misery is now. We know what the migration challenges are for foreigners that receive in our offices. We try to help them at the border itself. I remember that the obligations, rights and obligations have to be respected, and here it's difficult to applicable according to the place of birth. We have training actions for our colleagues. It's a very technical, this rights for the foreigners. It's administrative right, criminal law, civil law. The colleagues cannot be only specialists of criminal law or administrative law. So it's a whole subject for itself, which is recognized nowadays at the level of the specialization. Means that you have to be trained at the European law. So training periods are organized. I want to cite to my colleagues present here in the room that at the Court of Justice, Court of the Human Rights, is organizing trainings for that on this reduced delay about the period in which the Court of Human Rights can tackle a subject. Hélène, you spoke about the pact, migration pact. The National Council of the Bar has given a report on that subject, together with the CCB, to denounce a certain number of the weak points about the legal assistance, about the foreigners that will be screened, and about the independent control. And we elected person in the Commission Liberté is working on that, and she is part in this committee with Noemí. And we have 2 things that I would like to underline. Philip Worthington is absent, but I want to underline the activity of the ex-president, these lawyers of urgency, 2007, when there was a crisis and the externalization of the work that's been done, this the creation of the so-called hotspots, these camps, in open-air camps, to prevent the entry of foreigners into Europe. So some country had the heavy duty, was Greece, Spain, Italy, to limit the arrival of these foreigners with agreements between Turkey as well. So CBC wanted to launch a sort of judicial support for the doctor as well. So the migrants are aware of their rights, have access to the right through benevolent lawyers, and in which the National Council entered into the Administration Council after the visit of Terrachul. In Lesbos, where she saw how minors were treated, they were sleeping at night, not to be ill-treated during the night, you know, because this is no surveillance. What happened at night was distressful. So, what we would like to do in the framework of the borders in France, the question of the borders, you participate to that, I know. It is a legal support, legal aid at the border, Italian-French border. So we can bring judicial assistance between all the bars. So the foreigner, as soon as he's at the border, can enjoy legal aid, coordinated with others. And so the National Council of the Bar could give training to the people concerned, access to aid to the migrants in the areas in which they are, what we call the jungles, and all this within the convention. So the judicial assistance would be done from the beginning to the end with the assistance of the bars. It looks modest, but finally, this effective access to the right will not be virtual anymore. I hope respected the time that was given to me. Thanks a lot, Laurence. I'd like to give the floor to Noemí. ALARCÓN, VELASCO. What do you think about this Schengen law, which would allow a state not to respect the common law? Thanks a lot. I will respect the time that was given to me. There are a certain number of rules which is touching the right of refugee, asylum right, that can be questioned. It's actually principle of international law, the principle of non-sending these asylum seekers back. It's part of the Geneva Convention of '51, and it's part of the European law, the Charter of the European Union, article concerning a right for asylum, Article 18.2, which recognizes the principle of non-sending back this asylum seekers, collective asylum seekers, Convention of Human Rights. There has as well accepted this principle in Article 3, and so this is recognized as well in Protocol 4. These principles which cannot, we have to accept. So you cannot just, the member state cannot just choose the rule they want to to apply. It's true. We have a pressure. Pressure, not the pressure, normal migration pressure, but it's used as a political weapon, as a war weapon, I could say. Is using the people by another state to make a pressure at the border of the European Union. The second case that we have been confronted to, which was in May last year, was something similar at the borders of Spain with Ceuta. You know, that city, was menaced because we used the people, mainly minors, children, adolescents, pushed by Morocco to cross the border, so they just to exercise a political and economical pressure on Europe and geostrategic pressure, so to speak, against Europe. So each time the states, which are our neighbors at our borders, use this type of weapon to change our Schengen code, which is a common rule for asylum, I think it's difficult that there are derogation clauses, and I am against the fact that a general principle will suddenly offer derogations. And all of a sudden, this principle don't exist anymore. And we haven't a procedure exist. With this pact, with this Dublin regulation, we could find a balance in the situation. No, there are some principles that you cannot change, which are part of the rule of law. Is the judicial aid, assistance of a lawyer, so these people will not have access to judicial aid. So access will be denied through a derogation of norms to the standards. There's also these procedural guarantee will not be given anymore. So I'm against the application of this derogation of the Dublin regulation without having the guarantee and without having an approach of human rights in this assessment when it goes to modulate access to a territorium where there is a humanitarian crisis at the border of the European Union. Against it. Thanks a lot, Noemí. I would like to speak now about Philip Worthington, which concerns Lesbos. He's the managing director of the Europe in Lesbos. What is happening on the ground as far as the assistant is concerned? I will try to answer the place of Philippe. I try to imitate his accent if I can. As I said before, the idea of the lawyers was to say, we're not going to wait to foresee, to wait that we are here present. We are going to do it ourselves. The idea of the CCB was to send these benevolent lawyers. Now it's very structured. With, at the head of it, Philip Worthington. Permanent people are there on the island of Lesbos itself, in Athens as well, in Samos. They will have a certain number of interventions, and they ask the administration if they can extend their duties. So what is at stake? The foreigners arrive in these so-called camps. the job is externalized. They are screened. You will see if you have the right to enter or not, if you are an asylum seeker or if you will send back. So they can stay there for a long period of time. According to Greece law, there should be a judicial assistant at arrival in this camp. But asylum, for the asylum application, it must be very well written. The asylum seekers must describe their situation of persecution, the risks they have, according to that general situation. Now, if you don't have a judicial aid, a support of a person, which actually a technical application, according to Geneva law. So, first thing is, Philippe suggesting, is this assistance. Legal aid, which is not foreseen by the Greek authority. Second thing, do it very quickly, because today the questioning are done, the interview, within 2 days. Asylum seekers are not being said in advance that they will be questioned, so we should be able to prepare them to answer the questions. The foreigners are displaced to Athens itself while their application is working. They don't know yet that it has been refused. So in the office of Athens, we want to be able to follow the application that has been done. Last thing, all this job. What happens in the camps? We have to know about it. There is a fragility about his associations not being registered by the Greek authorities. We find ourselves in a situation in which politically you have to respect the law, the framework of the regulation, to have the right to stay in these countries. You have to respect the law, of course, but at the same time you want to have a critical view of the situation. So the challenge of the registry, so Washington wants to work on that, Philippe. And so we continue to support Hélène in this work judicially, to be able to offer this assistance that should be done by the European Union, actually, and in which actually the jurors do what the states are not doing within the framework of the agreement at European level. My colleagues that are interested, my colleagues can go there to be benevolent, be there for 3 weeks at least. If you want to do your job properly, you are trained before. You have to speak English. During the sanitary crisis, you can do work with visio conferences to ensure the assistance. It's a very good project. Of course, it would be better it wouldn't exist if the states would do their job according to the European agreements. So we can go further into details about what is lacking and the different conditions of work. I'd like to add something about what Philippe should have talked about it. It's add something. Hélène does a remarkable job compared to with what I call vulnerable people, to do this judicial aid, legal aid, especially for children, non-accompanied minors, like in Lesbos, or judicial aid in Athens itself, but especially in Lesbos, in this camp, retention or detention camp, we call it, where there are many adolescent minors, as I said, non-accompanied minors. So they do a remarkable job there as far as education, re-education of these children with these applications which are presented. So the assistance of a lawyer, what we call, it's a concept that is, which I use in English, early legal advice, early, I could call it early legal advice. And this linked with the screening regulation, which it's not foreseen that there is a legal advice, the presence of a lawyer in these procedures. They don't call it procedures, actually. They consider it as an administrative procedure. The European Commission has said it's not a procedure. So imagine, it's outside the norms of application, outside the standards of application of law. So what Lille is saying is this necessity to have this judicial legal advice right from the beginning, because here it's when everything is decided in the first hours of the arrival of the migrants, when their rights, obligations are given to them, what are the procedures that they have to fulfill. The lawyers have to, in the coming days, respect. So it's fundamental, the work that is be done right at the beginning. As Laurence said, it was not foreseen in the norms of the European system of the right of asylum that there will be a legal advice in the first steps in this administrative so-called phase. It's foreseen for the later phases after the screening. So it's good that the European Union has planned something in the new standards proposed for the asylum procedures. There will be legal advice in the first instance, but not now in the new process. It's not yet at the early stages that it is applied when the person arrives at the door of the European Union border. Noemí, I turn to Leyla KAYACIK, which takes the place of the ambassador, Stefanek. I said it's very important, we have to know. I turn towards the Council of the Bar. How can the European Council guarantee access to the rights? It's a real pleasure to be with you today, a real honor to have been invited in my new function. I started actually a few days ago, and this roundtable enables me to enter into the subject itself. It's good that the Council of Europe is invited in the framework of this conference. So the office, the office of the special representative of the General Secretary has been created at the beginning of 2016 after the migration that arrived was in 2015. I'm the third person now, special representative in this field. The Council of Europe has its seat in Strasbourg, 47 members, as you know. With them, of course, the 27 members of the European Union are part of the Council of Europe, sure. There is no convention that is strictly dedicated to defense of the asylum seekers and refugees, but we have, since 1949, developed a corpus, so to speak, of organs, conventions, regulations. We have the follow-up organs, which are looking after the application of the standards by the member states. So as far concretely, effective access of the migrants' rights. the Council of Europe contributes directly through its standards, norms, and through its organs to the protection of the asylum seekers, the protection, of course, of human rights, and jurisprudence developed by the Council of Europe in this field. I think it's important to underline that it doesn't give a right to asylum as such, the convention. The convention doesn't give a foreigner to enter and to remain on the ground of a country of the member states, but as soon as they are dependent from the law of the national state, independently of their nationality, benefit from the protection of the convention. So what I mean is the right of the member states to check the entrance of these foreigners is done in application of the convention. So the court is a very important institution to guarantee the access, effective access to these rights. We have as well a convention which is maybe less known, part of the European Social Charter, which has a control mechanism as well and a follow-up mechanism. The member state make a report. There's a system of collective reclamation that you know perhaps give this the possibility for international organization, non-governmental organization to make collective reclamations in front of the Committee for Social Rights. And as far as the Social Charter applies, of course, to the foreigners which are working legally, which are legally here or work regularly on the territory of the member states. But it applies as well to the refugees and other migrants, apatrides and other migrants. But you have to say one thing. Recently, the Committee for Social Rights has extended jurisprudence in order to protect as well the person that are in an irregular situation and which have to benefit a certain number of rights foreseen by the Charter, for instance, medical and social assistance, and the right to have to be lodged. Charter, as I said, we have the Committee for the Protection Against Torture, CPT. Same name for the convention is the Convention for the Prevention of Torture and Humiliating Treatment, are here to control the places where people are deprived of liberty, and so far the CPT has developed detailed numbers about conditions of the detainment and the mechanism of control and the way they can ask for different control. You have the Greta. Greta is a follow-up organism making controls in the countries, making reports with recommendations. And this convention covers as well the migrants and refugees in some of its proposals. I would just want to give you a broad idea of all the instruments that we dispose of and which are not always well known. We have as well the Convention about the prevention against violence against women, domestic so-called violence. It's a Convention d'Istanbul, it's known as such, which has a whole capital about migrant women with papers or not, and asylum seekers, which suffer from discrimination according to their gender. Now, this convention is acting in violence done on the basis of gender. It gives the possibility to migrant women which are victims of domestic violence and whose status depends from the husband, has allowed to give a sort of autonomous residency. I mean, when a person is ill-treated, a woman is ill-treated, she can keep a residence permit and she can live autonomously from her, far from her husband. Then you have the Commissar for the rights of human rights, which is visiting the member states, making recommendations, very concrete recommendations, which cover the situation of the migrant and asylum seekers. Committee of Ministers, of course, is adopting recommendations as well. How can I say, in the 40, as I said, 47 member states, it must be a consensus, adopted by consensus. Then your parliamentary assembly, which is making a lot of reports as well on this subject. The Congress of Local Powers and Regional Power. Just to give you a broad idea about how, in which field the Council of Europe can contribute to make the right more efficient at international level. Merci. Thank you, Leyla. We go now to the second subject. It's the monitoring part. First question to Laurence. Laurence, about this control monitoring mechanism that has been suggested. It's an independent, as I said, monitoring possibility of at borders at the European Union.
Thank you, Hélène. Yes, indeed, you're right to insist on independent, because if it needs to be independent, it has to be to have the necessary resources to be independent, and it should have a role to play, and not just some sort of novel language. You know, this pact doesn't plan on legal aid, doesn't plan on the assistance of a lawyer. We've been talking about this for half an hour, and it is planned in this mechanism that the member states implement sufficient guarantees to ensure the independence of a control mechanism to evaluate the practices of the member states at the borders of the European Union. Wow, that's great. And once you've said that, what happens? In reality, let's make it simple. If you want a real independent mechanism, then first of all, you don't leave the member states to choose how they will guarantee the independence of that mechanism, which idea, if I understand, was to have a sort of control of migratory policies and to denounce whether these policies attempt to the fundamental rights. And we know they will, because the pact reaches to these fundamental rights. So first of all, if it's to be independent, it should be compulsory and not just optionally have independent international organization, whether it be NGOs or member states where you have this detention centers, so NGOs. Also, administrative authorities that would be independent. As we know, for example, the general controller of detention locations in France or in other countries, you have these independent administrative authorities with ombudsmen, possibly. And then you have to have the possibility to have an unexpected visit right. So if you just ask for a report for on organized visits, it's not going to produce much. And I think it will be the strength of these independent mechanisms to have its own independence to decide to organize unexpected visits and to report on that, to come with journalists, as the members of parliament can do, on a number of detention places. We know that this exterior stance, when it is public, obliges the member states and the states to justify themselves. So if you don't have this unexpected visit right, the possibility to have journalists accompanying the delegation and an independent composition, you may say that you have an independent mechanism, but it's not worth much. And I will talk about this in the third part. These authorities should have a visit protocol, as the controller in France does, with sheets on whom you may interrogate, and passing beyond the organized visit rights and mechanisms. So if we have that, yes, that mechanism could be interesting, but it will never be able to replace this obligation of the presence of lawyer. And we know that we bother the general atmosphere if we're not in the legal aid mechanisms, because it's really the emancipation of anyone to have the right to information to assert his or her rights. So it would be insufficient in any case. Thank you, Laurence. And as an extension of what Laurence just said, what are the messages that the CCBE would like to bring forward for the lawyers to the Frontex agency? I remind that Frontex is the agency of at the borders of Europe and the coast guards of Europe. Yes, okay. Picking up on what Laurence said in relation to this control mechanism, I think that at the moment, well, I don't know what the member states do, because it's up to them to choose what they do, but I think what sort of it's coming up is that they will designate perhaps an ombudsman, or if the national mechanisms for the prevention of torture, it could be designated people for, in particular, for this mechanism, this control mechanism and the claim mechanism, because there has to be a way for the migrants or refugees to file a claim, because there has been disrespect of their fundamental rights. So it seems to be in the air, this ombudsman mechanism. And the United Nations have pointed out that ombudsmen and women should be taking part in this control mechanism. So, but it's not yet defined. It's not yet precise. And this control mechanism also in this in the Schengen Code, which is related to Frontex. It is also planned in the new regulation that there will be a control and claim mechanism in relation to violations that would have been committed by the Coast Guards working for Frontex, for example, or Coast Guards or police forces who would work in joint operations, and also in the state where these national police forces would intervene. But that is already planned. What regards the competences of national police is planned. It's in there. What's the jurisdiction? What are the recourse possibilities? Is already there. But what's not exactly in place at the moment, as Laurence mentioned, is really the mechanism by which things will happen. Who will do what? And I'm talking about the one concerning Frontex. I'm not talking about the one for the filtering and regulation purposes. So it's being developed at the moment, and we have had the occasion to take part. We are now on the advisory board for fundamental rights on Frontex. We've been able to be in these consultations, and we've been able to propose our own stance as lawyers, how we can have a control mechanism effective and in place so that there is really an effectiveness, an efficiency of this mechanism, that it not just be something that's philosophically nice and up in the air. But it's great, it's fantastic, but if it's not efficient, if it's not practically implemented, and if you don't have a report on what has been done after a claim has been filed and who decides what, then it remains vaporware, and it's and you don't have anything, you don't have decisions, sentences that are done. So that's our position in relation to this work, and we are in this advisory board, so we are doing some monitoring and some independent control in terms of fundamental rights at the borders, and to operate supervision of this approach of compliance with human rights and fundamental rights within the European Union. And also to look at insist on the role of lawyers and legal aids at the borders of Europe. That is something we will mention after in just a moment. Really underline, highlight the role of lawyers, and it's really fundamental, I believe, to really insist on the role we have to play at the borders of the European Union and in the territories, wherever. Thank you, Noemí. Thank you, Noemí. The question that was to be addressed to Philip Worthington was, what would be then the most adequate system to guarantee the fundamental rights? And in relation with Lille is on the field. It's the example that we can have as a basis of those rights. We have to hurry a little bit because we're constrained by the time. I think, yes, okay, I'll be quick on that. Philip Worthington shares our views on this independent authority, I believe. And of course, the ideal situation would be to have a legal assistance as of the arrival to the borders, because as Noemí said, it's really at this time, at this precise time, that you need legal assistance, and where it's important. That is the right to information and the possibility to organize one's defense and to work out the asylum request as best as possible. And in terms of compliance, of standards, a good size, and in terms of minors, there's also the imprints, fingerprint taking, there's a facial recognition. Well, this is not science fiction anymore. And so the assistance for the most vulnerable and for minors in particular, that assistance should come right away, and it should be unconditional. It should not be an assistance potentially for entering. No, it's an assistance for all right. It has to be unconditional. The right to education. It's not just asylum right. It's a right to protection, the right to life, the right of the minors. So here again, you need to have competent lawyers in terms of minor rights, and it's also the protection against this criteria of safe countries, so-called safe countries. You know that for all nationals of safe countries, of which Afghanistan, Syria are among safe countries, yes, okay, it's a majority of those who come at the borders of Europe come from those countries. Now, for those nationals to file an asylum, you have to prove that the country is not safe. So it's not anymore you file asylum and you have to bring the proof that you are persecuted despite the fact that your country of origin is unsafe, is safe, sorry. So we need to have this end of this safe country criteria. And we know they're only chosen just for political reasons or economic reasons because they really supply the big contingents of migrants. We do that as lawyers to the Conseil d'État. We've been able to change some of the criteria on safe countries that are not anymore safe countries. But we have to fight this for each state, but we have to do that at the European level. It's also, yes, we have to work on this, the end of the criteria on these so-called safe countries. Well, it's always very interesting to discuss all these matters, but we're really time constrained here. And I'm now turning to Leyla to find out whether the Council of Europe is really interesting for the Council of Europe. Are there interesting recommendations or? But in fact, that proposal, you were talking about this proposal of the European Commission. This mechanism for an independent control at the borders, it could be the National Institution for Human Rights, as you mentioned, Ombudsman, but these mechanisms should abide by the standards of the Council of Europe. We won't go in the details, but there's a whole case law of the court in terms of effective recourse, how it should be implemented, and there are standards that are edicted by the CPT. And we also have recommendations on the national institutions for human rights, how they should be organized, should these institutions were to be chosen as independent control mechanisms. We also have a recommendation 2019 on the institution of ombudsman. So, and these mechanisms really have to abide by these standards that are elaborated by the Council of Europe. That's our requirement. Thank you very much, Leyla. We are now moving on to the third topic, and the third topic is also very important because we are going to propose to talk about proposal and outlooks for the future, and we have to work on agreements, and this has to be brought forward by the French presidency. What are the proposals of our trade, of our activity as lawyers to improve the protection of the rights of migrants? Now, those proposals were done in the Pact for Immigration that you can read on the internet site of the CNB, the right to assistance by a lawyer. That means the right of assistance on a free basis with a compensation mechanism, a legal aid system. It's a real issue at the European level, this legal aid question. It's an issue in France, but in the European Union, it's a major issue. This right to the assistance of a lawyer presupposes the possibility to have an exchange in a location ensuring confidentiality. For example, the camps in Moria, in Lesbos, don't ensure anymore any confidentiality. Before the fire on the camp, you had this little booth that was sort of ensuring some confidentiality. Confidentiality, that's over in Lesbos, in Moria. And so that's an essential issue. The possibility also to be designated freely and at any point, that is as of the arrival to the border, and access, full access to the file. The PACT project doesn't plan on this full access to the file, and I've said this many times, and we insist on that. You said that in this outsourcing system, it's really an administrative process, and that's what's planned in this outsourcing. I am saying it should be motivated, and there should be a recourse possibility against that decision. Otherwise, it's an arbitrary thing, and we will go to the European Court of Human Rights for that. Now, more generally, besides that assistance of a lawyer, assisting individual, you have the visit right by the lawyer. You know that we have this trust law that has been voted, and it's a big progress that was not desired by all actors, as a matter of fact, but the profession insisted on that. The amendment was sustained, and we have a right to visit in all places of detention, except psychiatry places. It can be deplored, but that's another thing. But detention centers, and retention centers and custody places. And for police people and for the personnel of retention, it's going to be bizarre because we've been asking for this for many, many years. The idea is wherever there's a detention, there has to be a permanence of a lawyer. Because, you know, on the weekends, it's complicated. So legal aid is complicated on the weekends, for example. It's never been implemented by the Ministry of Interior. But with this right to visit, the president of the bar can at any point in time visit a detention center, a prison, and of course retention centers. And the profession will elaborate a guidebook to educate the presidents of the bars to do that. But it's going to change lots of things. It's a founding thing. And I think we should be able to do the same thing at the European Union level, that is, enable the bars to, in their countries, or it could be other bars, to have a right to visit in detention places. So I think it's also something that we sustain, we will promote in the framework of discussions, upcoming discussions, and I'm sure that I can count on the DBF and the CCB, of course. Thank you, Laurence, and thank you for this extremely important progress. We really fought for this, and it's a great, great progress so that the president of the bars can visit these detention places. And I'm now turning to Noemí about this legal aid, free legal aid. What is the situation now? Okay, just thank you. Just to pick up on what Laurence just said, we have, and I'm not talking of the CBE, but the country where I come from, in Spain, we have in the legal aid protocols for migrants within the national bar of Spain, we have in this protocol integrated a mechanism of control where the bar, the president of the bar or the bar, could come unexpected anywhere if there is a problem signaled by designated lawyers. The president of the bar could directly visit unexpectedly. You know, we have retention centers. It's more retention, not detention center, retention center. That would enable a unexpected visit or a visit, organized visit, when really the legal assistance is provided. And so it was, it is, I think it's been implemented before the pandemic. It was not implemented, but the bars locally have organized this sort of visits by the bar or the president or the president of the bar. So that is possible. It's a very good idea, and frankly, I support this, and I think it's something we should propose within the European Union to have this sort of a mechanism to organize and to control, to organize visit and control how legal aid is provided in such places. Now, for the CCBE, we have organized a consultation with all the member states who are part of the CCBE within the committee, the migratory committee I preside, to see what is the landscape, what is the situation of legal aid and legal assistance in each of the member states. Now, of course, we don't count in the European Union. We don't want to have a common system for legal aid and legal assistance for migrants and refugees. So starting from the fact that we have all different systems, it would be important to start to work on a common denominators for this legal assistance, legal aid provided to migrants. And of course I defend, and that's what I've been doing here from the start, we don't want just to have legal aid from the onset of the procedure on, but also to have legal assistance and legal aid going beyond that, not just the first phase, but really contemplate the fact that lawyers can assist in a different way through mechanisms that the bars could think of. For example, have open days, open doors, legal assistance bureaus organized by the bars, so that anybody, any migrant, refugee, foreign national, have free consultation, free advice in a specific office. Some countries have organized that, not in all countries of the European Union. It would be interesting to have this, and so that it's not just up to the member states how things will be done. Not just detention, access to territory, but that it is a basis for in the legal system. Because the first step for the integration of these people is they need to have the knowledge, the legal information, their right, their duties as citizens of this new country they arrive in. And it's also part of this path towards integration of these populations. It's fundamental that they have a knowledge of their rights and duties. So it's an important step forward, which is why we organize this consultation, so that in the future we can make concrete proposals for the European Union for improving this legal aid and legal assistance system. And let me raise another delicate question, but it's not just something for the future. It's already there in all member states. Who is providing legal aid, legal assistance? It's not defined in a consistent way throughout. It's not legal aid controlled by the bar as we know it in France, in Spain, in Italy, but where it's really left in the hands of other actors of this legal aid system. So to have this common denominator, common rules that will enable us to move forward, so that everywhere anybody has access to legal aid or legal assistance. And legal aid is not happening at the same levels in all member states. That is, you have countries where it's only in case of tensions, tension-prone regions. In some other states, it's not planned at all. It depends. It's a very varied landscape here. And on the other side, I would like to say that it's very important here to address the compensation of designated lawyers compared with other matters. And it's really something important for the profession, because the way the services are compensated are very different from one country to the next, but it is something that will have to be addressed because it's a very small compensation, and for services that are emergency services and humanitarian crisis-prone situations. So it's really something to control and to implement by the bars and national bars, but also within the CCBE, the European Council of the Bars, to see how we can improve things. Oh, thank you very much, Noemí, for these proposals. Very interesting. We will have to conclude in 5 minutes, and I will leave the floor to Leyla KAYACIK it's never an easy task to end a morning of discussions, but I know that you have published, the Council of Europe has published a plan of action for the protection of vulnerable persons. And in that context, we just have 5 minutes, the main things in this proposal. Okay, yes, the representative is supposed to coordinate all actions of the Council of Europe in matters of migrations. And in that context, we have adopted this action plan 2021-2025 for the protection of vulnerable persons in the context of asylum and migration situations. So examples of what has been done. We have adopted a directive on the efficiency of legal aid system in the administrative and civil law, and that could be also of some help for you. There has been also the recent adoption, if you follow the website of the Council of Europe, you will be able to find this. You have a sheet that has been published presenting the measures adopted by member states to implement the ordinance of the court in matters of migration and refugees. That could be interesting also for you. We also have drafted a guidebook for the placing children of separated families. All this is on the Council of Europe and also the site of the special representative. And in terms of finalization, something interesting, there's a recommendation that is being prepared at the moment on the aid assessment, the determination of age assessment, determination of age, and how to define the age. When somebody says that they are under 18, and they may not be. So there's a recommendation that is being prepared, and I hope will be adopted in the months to come. We also have a project of recommendation of migrant women and asking for asylum. So we have a number of things that could be of help to the member states. And also, Noemí, perhaps you could say a word on that. We have also some trainings for professionals. Lawyers are also concerned by these trainings and in this respect. And one of the objectives of this action plan is really to continue this. It's called HELP. I don't know if you know that program. And Noemí, would you like to say something? I'd be happy. Somebody else would conclude, and Noemí knows, in fact, about this. Just 1 minute, 1 minute. Yes. France and the DBF are part of these trainings, and these are free trainings and organized by HELP. I'm sure you know that system. We have indeed 3 on immigration, but I think in France it's migrant and refugee children. And the other one has just been updated with some novelties. It's asylum and human rights, which is just came up in its new version. It's already online in English. It's not yet translated. And I've had a chance to draft this project with my colleague, my Greek sister, Danae. So even this is not tutorized, you can do that online. It's a great format because it's really, how would I say, interactive. Yes, it's interactive, and it's very easy to use. You just have to give your email. You have a profile, and hop up. You are on the training course, and you can go move forward, backwards, and it's really with images. It's really graphic, intuitive. You really have a picture of the situation, and then you can go to the standards. Okay, yes, an ordinance. Here is an ordinance that I could use for such and such situations. And then you move to the page and you have the fundamental ordinances and sentences and things and legal texts from the Council of Europe, but also European Union and also the international standards. So I encourage to take part in this. Alternatives to detention. It's not yet authorized in France, but that's really 3 training courses. I'm always saying the 3, if you do the 3, then you have a master's in immigration rights and rules and law. So thank you very much to this panel and this roundtable panel, and have a good lunch.